The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Orlando. Welcome to another Ask the Experts, where we bring you the top experts in the field of legal, health, financial, and home improvement. We have been doing this show for almost 10 years now, and our guests today have actually been with us for 8 years, and we just found out the other day, this is amazing, we got a email from, I believe it was I think it's iHeart, saying that this show here that we're getting ready to present to you is one of their top shows as to listeners and viewers. So we are so excited about that. So without delaying this any longer, let me introduce you to, we've become like good friends now because him and I have been doing Orlando and Tampa both together. Now, I guess looks like we lost him.
Nope, I'm here.
Okay. Alan Swartzide, who is with K. Bender Renbaum. We are talking community association law. Alan, did you get to hear what we just heard from iHeart about this is their top show, top 10 shows? That is amazing.
It is, and you know what? The timing is extremely convenient because it's right after I started joining on your show about a year ago that this happened. I'm just going to throw it out there. I love all my partners and all of the people that work with me, but let's be realistic.
You're going to take credit.
I'm going to say.
I love it. He's going to take credit. Well, listen, the show is about you asking questions to Alan. And I got to tell you that we have so many ways for you to respond. First of all, you can actually call into the show at 561-623-9429. That's 561-623-9429. Or if you're watching us on TV, we've got a chat line that you can write your question in. Alan will see the questions and we will answer them. Or as we usually do during the month, you can text us at 954-336-3767. We got so many questions this past month, and I got to tell you, we appreciate everybody taking the time to do the questions because this is for you. This show is Alan and a lot of the attorneys at K. Bender Renbaum. They take the time out of their day to sit here and they answer your questions. So if you have a question, again, we're talking community association law. And Alan, we are getting so many new people every week. So if you don't mind, tell people about K. Bender Renbaum.
Sure. Well, the firm's been around since the 1990s. In at least this iteration with Robert Kay, starting the firm with a partner and then branching off. Mike Bender joined lots of years ago before I joined in my first iteration with the firm back in 2010. And Jeff Renbaum joined, and everyone is now fully immersed in the K. Bender Renbaum lore. And it's been a great experience being back for the last year after a little while away. You find out very quickly when you work with guys like this that the grass is definitely not greener on the other side. So I'm happy to be back But the firm practices exclusively in community association law. We almost exclusively represent the associations and give guidance like this. What we're going to provide today. Obviously, can't give what we would call legal advice, but we're happy to provide some guidance as to how Florida law generally works. And we do this on a very regular basis. I had a condominium board certification class just this week. We offer probably 12 to 13 actual webinars. And I love doing this with you, Steve, because it's kind of like what you mention all the time, that we do the Q&A sessions that are just ask anything. I like the opportunity to not be shoving information regarding a specific topic down everyone's throat, even though I do it in an enjoyable way. But this is just a lot more fun. So we've got 20 attorneys' offices in Broward County and Pompano Beach, in Palm Beach County, which is in Palm Beach Gardens. I am in our Orlando office, and we also have an office in Tampa and then Miami by appointment only. We've been doing this forever. It's all we do. And if your community doesn't have counsel or doesn't have counsel you're 100% thrilled with, we'd love for you to give us a shot. So, I think that's enough for the plug. Let's get to the questions, Steve-O.
Yeah, you know what? And also, if you'll look down on the scroll, if you're watching on TV, you look at the scroll, all the events that you have coming up this month.
Yep.
You've got so many things coming up in July.
Well, and we tend to continue scheduling those throughout the month. We usually give at least 2 weeks lead time, but I'm 99% certain, in addition to the time that I'll spend with you in July, Steve, and as well as the one class that's already mentioned in that scroll, I'll have at least 1 or 2 other classes coming up. I know I have a board certification. I know I have an insurance class that, frankly, I haven't taught before, so we'll see how that one goes. But my guess is we'll add another 1 or 2 that I'm teaching throughout the month. And we just think educating the public is very important. It's very difficult for a lot of attorneys that practice in our area to understand this area of law. You get into attorneys that do real estate and they still don't understand HOA and condo law. So for individuals who are trying to serve on the board and frankly not screw up, I can imagine it's even harder, especially if you're a self-managed community that doesn't really have any kind of guidance coming in except for classes like this, articles like the ones that my partners put out in Renbaum's Association Roundup and Robert K's Legal Morsels. I mean, that's really what we like to do, is give as much education as we can. And frankly, it makes our job easier when people don't screw up and need us to fix a problem. And instead they're reaching out to us saying, are we doing this the right way? Instead of making that mistake up front. So,
God, Alan, there is so much to learn about being a board member. I mean, and now with the new laws coming out next year, even more than ever.
Absolutely. I mean, listen, the legislature kicks us in the can at least once a year. There were a couple changes that are actually good, in my opinion. There were a couple that needed to happen. The glitch bill for Senate Bill 4D from last year. And for those that don't know what that means, because I'm speaking legalese, that was the bill that changed the laws about what condos need to reserve, put aside for structural components of their buildings and things of that nature. The additional reserve studies that now need to be done. Some of that is being cleaned up, or at least the legislature thinks so. Some of it's worse, some of it's better, some of it's easier, some of it's not. But that's just one topic out of probably 10 or 12. And if you want to know what changed recently, I'd recommend going to Renbaum's Roundup on our website at kbrlegal.com. Check out Renbaum's Roundup. It's not the most recent one, but the previous one is our annual legal update for all the changes that were made. That's a really good resource because Jeff is updating it every time that we see changes in how that's going to play out. He's updating it with the same link. So you can just refer right back to that same link.
Well, speaking of a Jeff, we've got one of our first notes on here.
Okay.
Jeff, I hope I say this right. It says, similar to how recreational weed is legal in New York City, but not legal as a state law, can Florida city law ever supersede state law as it relates to community association law?
So there are about 5 different questions in there, but I'll handle the one that deals with community associations. And the answer is yes, it is feasible for a city, a municipality to govern something more strictly than the state does. That's just something that happens not infrequently. In fact, you forget about marijuana, but when we're talking about fair housing issues, what is protected as a class, when you talk about sex, age, marital status, things of that nature, there are plenty of municipalities that have specific regulations governing that issue. That is, a lot of the time it is much more strict, meaning that there are additional classes as compared to the federal or state laws. So the short answer is yes, as to a community association, you might have to deal with laws that are stricter locally than what you would see statewide or nationwide.
I got to tell you, I'm so excited. We have on our TV side, we have some of the greatest producers. And what's so nice about this is I'm going to give you questions that are people that are writing in right now. And you don't have to worry about if you have glasses, if you can see them or not. They're just right there. So I'm going to go to our next question, Juan. This is from Mike. In a co-op, FS 719, can a shareholder assign their rights to speak and be on committees to their renter, who is also the brother of the shareholder?
All right. So I've represented maybe 3 co-ops in 15 years of practice, but I do tend to know the answer to this. So FS 719, for anyone that's not familiar, is the Florida statutes, chapter 719, which governs cooperative associations in the state. And the question, can a shareholder assign their rights to speak? Generally speaking, probably yes, if we're talking about at board meetings and member meetings, things of that nature. You may be able to have a designated person if you have a reason that you can't personally say what you need to say. But I've heard attorneys arguing that there's no right to have a representative attend a meeting in your place, including attorney. So the question is, it's probably taken on a case-by-case basis. Take a look at either the bylaws, and this will answer actually both parts of the question, whether they can be on a committee. The bottom line is look at the bylaws, look at the, I'm trying to think of what it's called, the master form proprietary lease. And for those that don't know, that's the equivalent of a declaration of covenants, but it operates in a cooperative community. You're going to want to look at those 2 documents. Those are generally going to dictate who is allowed to serve on committees or not. If it's not specific and doesn't say that it has to be a member, I don't really see any reason a tenant or a co-occupant that isn't on the shares. And by the way that a co-op generally works is a little different from an HOA or a condo. So you're actually a shareholder in the entire co-op with a lease to operate and reside in your property. You don't actually own your property. You own shares in the community. So it's a little different, but generally speaking, 719, and I'd have to review the statute, frankly, to confirm this. But my guess is if you look at the bylaws, you look at the master form proprietary lease, that's where it's going to say yay or nay with respect to whether those people can serve on committees.
Oh, Mike's just showing off because he knew FS 719. That's what it was.
That could have been it. It wasn't a question he actually wanted answered. He just wanted to show off knowledge.
Yeah.
That's fine with me.
Absolutely. Thanks, Mike. Let's go to, here's a question that was texted in this week. It's from Brad at Winter Park.
Okay.
I love your show. I learn new things every month. I just wish you were on more. My question is removing damaged carpet and painting the floor or leaving the floor bare a material alteration? He wants to follow up with our covenants only states that we must maintain an 80% occupancy with persons 55 and older. Can our association deny purchase by someone under 55 that will have no occupancy 55 plus. Can we amend our covenants? So he got 2 questions in there.
Sounds like 3 questions.
Yeah.
All right. So with respect to, can we deny someone that is not intending to put anyone in there that's 55 and over? It depends what your governing documents say. If they only say that the owner has to be 55 and over and the occupants need to be 55 and over, then that would be a proper basis to reject their potential purchase. If you only have a provision that says that the residents need to be 55 and over, you still could have an owner who is 55 and over. Or I'm sorry, if you're going, let me step back. If your governing documents don't say that the residents need to be 55 and over, but the owner does, then I think you have your answer there. Whether you can amend your governing documents to address the issue, absolutely, but you may be forfeiting your 55 and over status depending on what the amendment does. I'm trying to remember now back to the original question, Steve, which was, if you can refresh
about the paint and the damaged carpet.
The material alteration question. Thank you.
Yes.
So the answer to that question depends whether we're talking about someone who's on the board asking on behalf of the association, which it sounds like is the case here. If you're talking about within a unit, changing the carpeting and all that, it's not a material alteration, but it might be subject to regulations within the declaration of the rules and regulations. A material alteration is generally going to be something that's in the common areas, common elements. Depending whether you're in a condo or an HOA, that's also generally going to determine whether a vote is needed. If you're in a condo, generally you do need a vote to alter material, do material alterations, which is literally anything that changes the way that all of your stuff looks. So that's what a material alteration is. It's changing the appearance of anything within the common elements. There are certain exceptions to the rule, but the general rule, and I don't think any of the exceptions apply here based on what you've described, unless it's protecting the association better than what you had before, you're going to have to get a member vote to change any of that. If you're replacing that carpeting, that flooring with the exact same appearance, so I don't care about underlayment, no one's going to see that. If you're changing if you're keeping the same appearance and replacing carpeting with the same carpeting, that's not a material alteration. If you're leaving the floor bare, that is a material alteration and frankly, possibly dangerous. So if you're sitting there and leaving just concrete, that's not really going to be beneficial for your property values. It might be a dangerous condition that you might want to put some covering on, even if it's, even if you do have to get a member vote because you're choosing to change from carpet to hardwood or to some other hard material. So I think that answered all 3 questions.
I think you did. My next question, we're going to come back to it because I have a feeling it's going to be fairly lengthy. It's about Bill 919. We're going to go to break first.
Okay.
The phone number here is 561-623-9429, or you can write us on the chat line. K. Bender Renbaum, Community Association Law. We're answering your questions today. We're going to go to break. When we come back, we have more with attorney Alan Swartzide.
K. Bender Renbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Renbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Renbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Renbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Thank everybody who's writing us live during the show now, thanking us for the show. And believe me, we enjoy bringing it to you much more than you probably enjoy getting it. And we've got some of the finest attorneys who do the show. Today we have Alan Swartzide, he does our Tampa show too. He'll be back with us next week. And then the letters that we're getting right now are amazing. If you'd like to call in, we'll take your calls at 561-623-9429. It seems like since we've gotten the chat line now, Alan, we get more people writing on the chat line, but you can do it either way. And then we've got probably about 25, 30 questions that people have written that we're going to be reading online. We realize, especially this time of day, people are driving home from work, and it's not as easy to call in while you're driving home. So any way you want to do it's fine. I was just saying, we got from Harold in Orlando. So can you talk about the new House Bill 919 for homeowners?
I can. I might.
Choose. You pick.
So it's essentially a lot of changes that are coming down for HOAs. And I appreciate you giving me the heads up, Steve, that someone had asked about it, because I have an extremely convenient resource from my partner, Jeff Renbaum, who prepared a legislative update. And I'll just very briefly go through each one of his slides. It should take me about 2 minutes, 3 minutes.
That's fine.
So,
this is for homeowners, though, which
yeah,
they normally don't. It's usually the condos that get everything.
Usually condo world is when things go crazy. But this year it was HOA world and things went very crazy, in my opinion. So I'm okay with this one. Board meeting notices now need to specify agenda items, except for in emergencies. I think that makes sense. You let your members know what's going to actually be discussed. It's been required for condos for a while. I don't really have a problem with that change. There were some changes to official records regarding the email addresses that are being maintained for purposes of notices. People can now ask to have their records, their email and fax addresses removed from the official records. The association needs to maintain those as part of its general roster, which again, that one makes sense. I like that you can ask to have it removed because frankly, at that point, if you're no longer using the email address or you move out of the community, it should come out of the association's records. If the association collects a deposit for any reason, that's usually going to be in the case of someone that's renting and is using common areas to bring, let's say, their furniture or all of their stuff into the community. Once the project is done, the funds need to be returned to the member or whoever paid it out within 30 days after receiving notice that their project is done. It's also for purposes of construction, which we see especially in newer communities, but also where people are just frankly redoing their entire homes, which is what we've seen more frequently after COVID, that, everyone's staying home, no one's selling, but they're sticking around and they're going to make their home exactly what they want it to be. If a member requests an accounting from the association for those funds, because you do have to keep the funds separately in a separate account, not commingled with any other funds, the association also has to provide that accounting. We've got the prohibition on kickbacks that we saw in condos down in Miami a couple years ago. Another makes sense, especially with what we saw down in the hammocks, where, if you are getting something for signing a contract with a vendor, those kickbacks are illegal and potentially criminal now, which it has been in condo world for about 5 years. You can be immediately removed for forgery of ballots, theft or embezzlement involving association funds or property, or obstruction of justice, which includes destroying association records, or not allowing copying of records so that you can hide your own crimes. That all makes sense. Disclosures for developer conflicts of interest when a contract is signed and that member is still a director. Let's see. Let's move on to the next one. Fraudulent voting activities are now a crime in a HOA context. Makes sense to me. And then fines. There's additional clarification as to how the hearing for a fine is supposed to work. So basically, you have to actually hold the hearing now, which there was some debate as to that issue and what happens when the fines are actually levied. And there was also separately the biggest issue, in my opinion, was that, and I don't recall whether it was part of 919 or not, but there's a new law that basically says anything that's in a backyard or not visible from the street is not something the association gets to control anymore, even if there are architectural standards or restrictions in place that wouldn't allow it. So if you've got a boat, you can now park it in your backyard as long as no one can see it from the street. Unfortunately, that doesn't say that you can't have someone that sees it from, let's say, across a lake if you live on a lake, or across whatever you might be crossing if someone can see into your backyard. It also doesn't address whether your neighbors can see it from their second story over your fence. So there are a lot of loopholes there that I really don't like, because people live in HOAs not because they love being controlled, but because they love that there is some level of control that protects their property values and protects them from being basically attacked by noises and other things, or from, basically ugly properties next to theirs. And so this is the legislature taking away the HOA's right to govern that stuff that people have a contractual agreement they will allow to be governed. So whether that is something that is unconstitutional and might be subject to challenge because there is a contract in place with people having a vested right to have that level of control over their neighbors, or at least have the HOA controlling what their neighbors do, I guess we'll wait and see if someone decides to take that up. I'm not going to be the guy that does it, but you never know.
Alan, why do you think all of a sudden, after all these years, these new laws are coming out with HOA?
So most of these laws are reactionary in nature, regardless of whether we're talking about a condo, HOA, co-op, whatever it may be. I don't know offhand, and I'm not saying that any particular politician was impacted by having something in their backyard and not thinking that the association should be able to control that because no one else can see it, but it wouldn't surprise me. So a lot of this stuff, that we talk about the hammocks when we talk about some of the things that are now criminally penalized. Condos have already had it for a while. The HOA statute's just trying to catch up to some extent. But I also think that some of the things that we've seen, the legislature is reacting to it. And within the last, year or two, there have been things going on in HOAs that at least weren't quite as noticeable until recently. I'm not saying they didn't happen, but they weren't noticed quite as frequently.
Okay, let's go to Steve in Sanford. He wants to know, does the 30-year preservation of documents apply to both HOA and condo associations? I'm having trouble finding the answer. Seems to revert back to just describing what the rule is for HOAs.
That's generally because there really isn't a rule for condos. And the reason for that is largely because in a condo, your deed refers directly to the declaration of condominium. So you're extending that 30-year time frame, if it even applies, every single time your property is sold. So the covenants apply to that owner because they're on notice. So a large part of it, and I'll just put it simply, although it's an oversimplification, condos really don't need to worry about that 30-year MARTA timeline. So that's the Marketable Record Title Act that we're talking about, where covenants expire 30 years after the root of title unless they are preserved sooner. That doesn't really apply to condos is the answer to the question.
This next question is sort of unusual. We've never had a question like this before. This is from Colleen in Orlando.
Okay.
She wants to know, do developers/investors buy votes or otherwise influence condo boards?
Well, it depends what you mean by developers / investors. You could have someone buying up half the units after the development occurred in the 1980s, and now they're buying them up. That's not a developer. That is someone who may qualify as what's called a bulk buyer. Frankly, I don't do a whole lot of work with that particular statute. But the bottom line is they're not buying up votes, but they might be buying up the right to vote. So let's say someone bought up 50% of the units in a condo, they now have 50% of the votes. There are certain statutes that govern what happens in that instance. But the bottom line is, yes, they are effectively buying the votes in the condo because they own such a large percentage. They get to govern what happens unless there's a supermajority required. Now, this could be someone that owns 25%. Okay, they've bought 25% of the votes by buying those properties, but you don't just buy, at least generally speaking, unless you're paying for proxies, which I don't think is legal, but I don't know of any law that specifically prohibits it. You're buying the property, and that unit in and of itself, that ownership translates into the right to vote on behalf of that unit. So yes, you're effectively buying votes. So technically, no. Practically speaking, yes.
Alan, when the developers turn over the property to the board members, because it starts off on a new property, it's run by the developers. Is that correct?
Yeah. So it's run by the developer, and then usually you'll have events that are described in the declaration. If not, they're described in the statute, where when this happens, you turn over one seat on the board to an actual member who has bought into this community. But the developer really still has control. It's just that other person has a voice. And eventually you get to what's called the turnover process, where it's not necessarily turning over ownership, except for the common elements. It's turning over control of the board is really what we're talking about. But yes, that's generally the process. So now that I've talked a lot, what was your question, Steve?
Yeah, no, it seems like that they wanted to know what are some of the things they should make sure is done when the developer turns over the property to the board.
So there's a laundry list of items that you'll want to look into, and that's really one that you want to run by your attorney.
Yes.
Most law firms have that standard. Hey, here's the list of what to look out for. And are going to be, wise and caring enough to ask the question of, hey, what's already been done that's on this list? But one of the biggies that I would mention is actually getting any amendments in before the developer turns over control. And the reason for that, when I say amendments, what I'm talking about is changes to your governing documents, not rules and regulations the board gets to make, but your declaration, your bylaws, things of that nature. Reducing the percentage of members required to vote in a future amendment, because you've got several communities that I represent where they need a 75% vote of the members, and 50% of the members, let's say this is a Kissimmee HOA, for example, that has 400 lots, they need a 75% vote to pass any amendments, and they're controlled by the members, but 50% of the lots are rented. So good luck finding those members to vote unless you have electronic voting and the members care enough to actually sign up for electronic voting. So that's one thing that you'll want to do, because the developer will generally have the right to either unilaterally or almost unilaterally, meaning without the requirement of a separate member vote, make those changes on its own. Sometimes it's just to add property. Sometimes it's to correct scrivener's errors that they made. But a lot of times it's to change literally anything in the governing documents that won't impact people negatively. So that's one of the things you want to do. Another one is you'll want to get all of the documents that, according to Florida law, the developer has to turn over. You want to get those in advance because, frankly, a lot of times when the developer is done, they're out. So you want to make sure to get that before they are out and off the board. Another big thing to make sure to get in advance of the developer walking away, so to speak, and keep in mind, you can always sue them, but you don't want to have to do that.
Right.
You maintain a good relationship because there are things that they will have to do. but you want to get their accounting, all of their records as part of those records that I was just mentioning, to find out whether they have funding obligations that they haven't been meeting because they're not required to until turnover occurs. You're going to want to make sure that there are, all of the warranties that they're required to provide for everything that the developer built out are provided, things of that nature. Any reserve studies that have been done, that's something you're going to want so that you know what funds you're supposed to be budgeting. Because let's be honest, every developer is going to under budget on purpose to make the community more attractive for people that are buying in. And then all of a sudden, when the turnover occurs, you realize you need to double or triple your assessments to actually cover what's being spent to maintain the association. So those are some of the big ones. I don't want to take up, frankly, this is a topic that we could probably spend the rest of this hour.
Right, exactly.
But those are some of the bigger ones that I can think of offhand.
I love this next one. This is from Jonathan in Sanford. God, you got a lot of people in Sanford who watch or listen to the show.
Well, it's where the courthouse is, so people are interested.
I got you. He says, I'd love to contact the lobbyist or attorney who pushed this new HOA bill to hopefully get on the board with some stronger laws next year.
Well, I like that you said you'd like to contact the person that pushed it instead of pushing the person that pushed it. That's good. Hopefully there's no violence being anticipated here, but bottom line, it's if you look at the actual bills themselves, they will say who promoted this thing in the first place. So I don't know offhand which legislator it was, but that information is public record. You're welcome to take a look. The condo committee of the Florida Bar tries to keep some of this stuff clean. That's a committee that myself and I believe 3 or 4 other attorneys within our firm out of the 20 are actively involved in. In fact, I'll be heading down to South Florida for the quarterly meeting in a couple weeks. And I know Allison Hertz is actually the head of that entire committee, is one of our Palm Beach Gardens attorneys, and is excellent and someone that really cares about this industry, just like me, Steve, just like you. But bottom line, yeah, I agree. I don't like the changes that were made for the most part, especially the backyard issue where, we had control over this for 30, 40 years, but all of a sudden some legislators decide, no, that's not going to happen anymore. It just makes no sense to me. So you have the absolute right to email, call, send letters to those legislators and say, this is a terrible idea and here's why. And, you're welcome to say, I've heard from several attorneys that, or at least one, that they think that this is a terrible idea and requires a glitch bill that you guys are probably not going to consider. So I feel your pain is about the extent of what I can provide right now, but trust that we will be pushing to clean this up going forward. It's just a matter of, unfortunately, you might need to speak to the legislators themselves to get anything accomplished.
Alan, I don't know why I've never lived in an association. And I'm curious to know the people who live there, what percent of them are very active on what is going on within the association?
Well, there are 2 different answers to that. There's the real answer, and then there's the answer about how many people think that they are active in knowing what's going on. And the amount of people that think they're active and think they know what's going on is usually around 50%.
Okay.
The amount of people that actually are active is usually about 10% in my experience. Ooh. And the amount of people that are active and know what's going on is closer to 5%. That's part of the reason you have boards that roll over. I just spoke with a community today that is a current client of the firm and has been with me for about 5 years. There's I'm sorry, excuse me. It's been a long day, Steve. There is a director on that board that's been there since he moved in 30 years ago, because no one else in that 30 years has been willing to take the spot. So when you ask what's the percentage of participation, it's almost always way too low. Wow. And there's almost always a huge group of people that are dissatisfied with what's being done in the community by the board, but have zero interest in taking on the responsibility of fixing it.
Hey, if you don't do anything, you don't have much room to complain.
Well, you might not have room, but trust me, people do anyway.
I understand. Let me go to Scott in Orlando. He is a board member. He said, I requested monthly invoices with monthly statements. The response I got was the monthly management invoices are not part of the monthly statement as they are not issued. Can you respond to that?
I'm going to try and decipher this. So it sounds like this individual is upset with the management company that works with the association.
Yes.
Because they're not sending monthly invoices for their monthly charges. And the reason for that is they probably don't send monthly invoices. It's probably just under their contract with the association, something that the association has to pay every month. So there are two places that, or actually really one place that I would direct, I think you said his name is Steve, which is directly to the contract with the management company. If you don't have a copy of that, it should be in the official records of the association. If it's not there, then the management company is probably not doing their job under the contract, and you might have a real issue. Whereas this issue of not providing invoices, depending on what's in there, it probably isn't one. It's probably a misunderstanding that they're not explaining properly that they don't do it because it's just the rate that you pay every month under the contract. You don't need an invoice because they're the ones paying it to themselves in reality with your money. But as long as they are paying the correct amounts under your contract and itemizing all of the additional charges, let's say for sending out notices of late assessment, sending out violation notices, things of that nature, as long as they're itemizing that stuff, I don't really have a problem with them not sending out an invoice every month because whatever's in the contract is what the invoice amount would have been.
We're going to go to the next two are going to be from people who have just written in just now. Let's go to Culpepper first. It said, also at residence takeover, terminate any management company hired by developer?
I don't necessarily agree with that. If the management company is directly affiliated with the developer, then yes, you might have an issue there. But I have seen, I've worked with several management firms in the past that represented the developer and stayed on and continued doing a fantastic job after the developer turned over control of the association. Now, a lot of people have the perspective of, oh, we have to clean house. Anyone that worked with the developer, we can't work with. I don't get that. That person has a fiduciary responsibility, if it's a management company or a manager, to the association, not to the developer. They may have a business duty to the developer, but they have a legal duty, which is the equivalent of a trustee, which is the highest duty imposed by Florida law, to the association. So if they're not doing what's right for the association, then you get rid of them, absolutely. But the reality is to get rid of them just because they work with the developer, no, I don't agree with that one.
Okay. Let's go to Ms. Schneider. It said, can potential or possible litigation discussed in closed meetings or only proposed or pending litigation? If so, how is proposed litigation defined?
So potential litigation and existing litigation are really the things that you can discuss in a closed legal meeting. That meeting still has to be noticed. You still have to have an attorney there to discuss it. Otherwise, there's no privilege and no reason to close the meeting. But the answer is yes, potential or possible litigation can be discussed in a closed meeting. It's not just what the association is proposing. So if you get a demand letter from someone saying, I'm going to sue you if you don't do X, and you don't want to immediately just do X, yes, absolutely. You can discuss whether to do that or how to respond, whether to submit that to your insurance carrier. Just because it's not the association that's deciding whether to sue doesn't mean it's not potential or ongoing litigation.
We're going to go to Rose in Winter Garden. We have two current members that will lose their home sale if the board is able to make stringent rules not contained in our covenants regarding 55 plus. Does this require an amendment to our covenants?
I'm not aware of any way you can have a 55 and over community without the declaration providing for that. In practice, you might end up with only people that are 55 or over, but I would think that would be an unauthorized restriction on how you can use your property if it's not directly in the declaration.
Okay, let's go to Jackson in Orlando. We have a separate fining committee. Do they have to open their meetings up to the residents also?
Yes. That was easy. Yes.
Okay. That was real simple. Okay.
Some of them are easy. Some of them require a little more explanation. That one's just a straight up yes.
Okay. And listen, again, we want to thank everybody for sending letters in, phone calls today, and it just makes the show go by so much faster. Your questions are wonderful. And we just happen to have this guy here who says he's with K. Bender Renbaum, says he knows what he's doing.
Listen, now you're putting words in my mouth. I told you I was with the firm. I never said I know what I'm doing.
That's right.
I'll say it now, but I hadn't said it before.
Let me see if I can get a couple more questions in. William in Orlando, voting certificates. Can you explain voting certificates?
Yeah, that's a pretty easy one too. Good choice. So it's essentially a document that says who gets to vote on behalf of one particular unit or one particular lot. It's usually going to be, if you've got, a married couple that own the lot or the unit, it's going to say which one of them gets to vote. If it's a corporation, it's going to designate one of the officers or the directors or whoever the bylaws say is going to get to vote on behalf of that corporation. But that's really all it is. It's a document that says who gets to vote on behalf of each individual lot or unit, depending what kind of community you're in, when you're having your members vote on anything.
Okay. Listen, I get all the other questions. I think are going to take a little bit longer. We'll save them for next time.
All right.
K. Bender Renbaum, Community Association Law Firm. Give everybody the phone number again, Alan.
Sure. The easy one is 954-928-0680. That'll reach all of our offices, all 5. So that, you call that number, you can reach anyone. If you want to reach me directly, my email, which I constantly thank my partners for making it easy, instead of A. Schwartzide, it's as@kbrlegal.com. You're welcome to shoot me an email if we can ever help out your association. That's what we do. It's our literal bread and butter, and happy to help out. And I know that my partners and all the attorneys in the firm feel the same way. We do practice statewide, even though my office is in Orlando. So any of the attorneys might practice anywhere in the entire state.
Well, I got to tell you, we actually had a property that listened to the show all the time who had another law firm representing him. And from the great job that you all always do, they moved all their business over to K. Bender Renbaum, which is wonderful.
They made a good choice. I mean, the bottom line is I genuinely believe that if you work with our firm on one project, even if you're not ready to move the whole kit and caboodle, so to speak, you're going to decide to after you work with us on that one project. So,
absolutely. Alan, have a wonderful 4th of July.
Likewise,
everybody if you get a chance, go out to Seminole Casino in Coconut Creek. Has the most amazing fireworks I've ever seen. If you don't get a chance, just stay safe. And we're going to be back with you again next week with more Ask the Experts. Thanks, Alan.
Thank you. And thanks, everyone, for showing up.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.